As long as you can see it for the record.
Sir.
Maybe you can call the paramedics to check me out.
Mr. Alanduk, will you stop talking, please?
We head to Wyandotte, Michigan for an arraignment. 35-year-old Reid Alanduk has been charged with disorderly conduct. A day earlier, Alanduk was arrested for causing a disturbance in public and refusing to identify himself to officers. Today, he appears without a shirt before Judge Elizabeth DeSanto to hear if he'll be released on bond. Alanduk is represented by defense attorney Corey Westmoreland.
Counsel, as to bond.
Your Honor, after speaking with my client at length this morning, he did assure me he would be appearing at all future court dates and understands the importance of doing so. I would just ask that all that be taken into account when assessing a bond on behalf of my client.
And sir, how long have you resided in the city of Wyandotte?
6 months. I'm off and on from Largo to Wyandotte.
Largo, as in Florida?
Yes, ma'am.
And so, sir, when you reside in Florida, who do you reside with?
My father. But I don't plan on going into Florida until this is resolved because I don't want to have to come back and get arrested for some warrants.
Well, I'm glad that you corrected yourself. If you were to test right now, what would be detected in your system?
Prescription medication. I don't do any street drugs. I could take a drug test, but I don't do any street drugs. I just do prescription medication.
Okay, and do you take those as your doctor orders, or do you take them however you want to take them?
No. My mom is a nurse. She has to hand them to me every day. I don't take them without a nurse's supervision.
Judge DeSanto is ready to set bond.
Given Mr. Alanduk's partial residence in Michigan, partial residence in Florida, the court wants to ensure Mr. Alanduk is going to return to court. The court's going to order a $3,500 10% bond, and the court's going to also order a GPS tether through Wayne County Jail. You're not to possess or consume any alcohol or drugs that are not prescribed.
She's not done.
And you're to continue to take your medication as prescribed.
But I don't have my medication on me.
I believe, sir, that you can have one of the officers contact your mom regarding your medication.
You don't understand, Your Honor. I have a blood infection.
Excuse me, sir, let me finish.
I'm gonna probably die in here. I'm just letting you know.
Sir, let me finish.
Just as long as it's on the record, you know I'm probably gonna die of an infection in here. And you don't care, that's fine.
Sir, please let me finish.
As long as you know I have a blood infection and a spinal infection, and I probably have meningitis, and as long as you can see it for the record.
Sir.
Maybe you can call the paramedics to check me out.
Mr. Alanduk, will you stop talking, please?
Miss Elizabeth DeSanto, yes.
When you're talking about a blood infection, I have no idea what you're talking about because I have not had any information regarding that. So, counsel, are you aware of any of that?
He mentioned it earlier. I'm not exactly sure what he was speaking about.
I didn't do anything wrong. I don't know why I have no $3,500 bond. For what? What did I do wrong?
Sir, you should likely not discuss the facts of the case because that is not what's before the court. Now, the court ordered a $3,500 10% bond, which is a lower cash bond based upon your.
Paying that.
Based upon your. Excuse me. The court wants to make sure that you are going to appear in court, which is why the court ordered the bond and a GPS tether through Wayne County Jail.
I don't even have a car to drive out of state. Why would you think I would skip court? Why? Why would I skip court? I follow the law to a T. Why would you think I skip court?
Sir, the court made its ruling based upon the information that it had. All right? So we'll see you back on October 15th at 10:45 a.m.
Later that day, Alanduk posted his bond and was released. But a month later, he was arrested for allegedly selling illegal drugs and is now being held on a $1,000 bond. Both of his cases are pending. Next, we head to Conneaut, Ohio for an arraignment. 34-year-old Christopher Barrett has been charged with violating a protection order. A month earlier, police say Barrett violated a 5-year no-contact order granted to his ex-wife when he showed up at her workplace. The alleged victim hid in the back of the store for 20 minutes before Barrett left the premises. Barrett's ex reported the incident to police, and he was ordered to appear in court. Today, he's before Judge Nicholas Irochi to enter a plea. Barrett is represented by attorney Joseph Loftus.
Judge, I would waive formal reading of the complaint and his rights and enter a plea of not guilty to the single count in that complaint.
Okay. Court will accept the not guilty plea. The law director's office is asking for a bond in the amount of $10,000, cash surety 10%.
Judge Irochi takes a look at the defendant's criminal history.
It says that Mr. Barrett has a history of drug use. When's the last time you've been through any kind of substance abuse or mental health treatment, Mr. Barrett?
Last time I was up here, I went through a company through my work. I did behavioral health there. I also did 18 months inpatient in Florida for substance abuse.
So when's the last time you've received any treatment?
Well, I haven't been able to really find a place to set my insurance because I can't seem to get a job here because of the protection order.
Yeah, you don't seem to hear my question and answer my question. I'm going to ask it for the third time. When's the last time you received treatment?
Last time I was up here, so about a year ago.
And where do you work again? What's the name of the company? How long have you worked there?
A couple months since I've been trying to move back and forth from Erie to Ohio. There's a lot by myself. I don't have any family here. My family's all in Florida.
Yeah, I don't need to hear that. Look, Mr. Barrett, you're in my court now. And when I order you to have no contact with someone, that means you stay away from her. You don't go anywhere near her. You don't have any communication with her. There's already an order in place. Look at me. You violate this order that I'm about to impose, I will make sure you sit in jail for as long as I can keep you there. You stay away from her. Do you got that? Do you hear me?
Yes.
I didn't hear you.
Yes.
Bond is set in the amount of $25,000 personal recognizance. Defendant is ordered not to consume or possess alcohol or drugs. He is subject to random chemical testing by probation and law enforcement. He is to have no contact whatsoever with Mr. Barrett. If you fail to abide by the conditions of your bond, I'll revoke your bond. I'll issue a warrant for your arrest, and I could order you to pay the state of Ohio $25,000 as a penalty. Understood?
Yes.
Barrett was released on bond, and his case is pending.
Show some respect for the court, whoever the court is. You don't have to feel respect for me, but you have to show respect for the
I am showing
position
respect,
I'm
but
in.
you're being disrespectful to me.
We go to Eureka, Kansas for an arraignment. 42-year-old Rihanna Johnson has been charged with driving with a suspended license and having no insurance. 3 months earlier, Johnson, a mother of 3, was pulled over for driving with a damaged windshield. And when the trooper learned Johnson's license was suspended and that she didn't have insurance, he issued her a citation and she was ordered to appear in court. Today, Johnson appears remotely, without an attorney, before Judge Phyllis Webster to discuss next steps in the case. The prosecutor is Jared Regier.
Your Honor, the state is recommending a bond of the very least $3,500. Besides the charges currently before the court, the state understands this is a defendant with at least one prior driver's license violation, a diversion for DUI, as well as at least one non-traffic felony conviction.
I haven't received a DUI. When did they say I had a DUI on that?
Your Honor, it does appear to be somewhat dated. Nevertheless, given the nature of the offense, the state does consider it relevant for purposes of setting an appropriate bond in this matter.
When was it dated, you said?
Approximately 20 years by the state's understanding, Your Honor.
20 years. So you bring up something for 20 years ago?
Sure he can. I'm not going to consider it, but for all the other reasons
Thank
he
you.
stated, 3,500 OR sounds reasonable, and I am going to make that your bond.
And why is that? Just because I have...
Well, you have a lengthy record, ma'am, starting in 2004 up to now.
I mean, I'm not trying to argue with it, but I don't have a really extensive record except for a couple driving on suspended.
Going back to your record, there's some children involved in some cases that I won't use
But
again.
that's irrelevant with this.
All right,
I mean,
look. Okay, are you going to let me be the judge and tell you what's relevant and what's not, or are you going to just take over the case?
no, but you don't have to be rude to me. I mean, but I don't know what my children have to do with me driving on suspended.
I'm not going to let you talk down to me like that when you're the one that's accused of violating the law, and then you come in here with an attitude trying to tell me how it's going to be.
No.
Stop.
No,
Ms.
but you're
Johnson.
bringing my children into it for why? My children have nothing to do with me driving on suspended. They have nothing to do with that. None of them cases do.
Judge Webster appears to be running out of patience.
Show some respect for the court, whoever the court is. You don't have to feel respect for me, but you have to show respect for the
I am
position
showing respect,
I'm
but
in.
you're being disrespectful to me.
You want me to make it a cash or surety bond? Because you're starting to show me an attitude that I don't know that you respect the court enough to follow the court's orders.
I do respect the court.
You just don't respect me personally. Is that what you're saying?
No, I do respect everybody, but I feel like I'm not being respected at all. But I will keep my mouth shut and you can proceed and I will come back with my attorney.
You are provoking the court, Ms. Johnson, and you need to stop it.
Despite the judge's warning, Johnson's got more to say.
I have a question. How far back do you guys go? I mean, use that against a person. I thought it was like 7 years.
I don't know where you heard that I can't use anything you've done after 7 years, criminally speaking, but I have never heard that law. They didn't teach me that in my law school. Maybe they did in yours, but not in mine. Ma'am,
I was just asking a question. You don't be rude. I was asking a question.
You know, I'm really trying to stay calm and not find you in contempt. But the way you are sassing and disrespecting and arguing with the court puts you in a position where I could find you in contempt, order you to pay a fine, and actually order you to serve jail time. Ms. Johnson, anything else you want to take up before I let you go?
No, Your Honor.
All right.
Johnson posted the $3,500 bond and was released. She's yet to enter a plea, and her case is pending. Next, we're in Eureka, Kansas for an arraignment. 53-year-old Danny Johnson has been charged with speeding and operating a vehicle without proof of insurance. 7 months earlier, Johnson was pulled over and issued 2 citations. When he failed to appear in court, he was arrested and released on $1,000 bond. Today, Johnson appears from a separate room in the Greenwood County Courthouse without an attorney before Judge Phyllis Webster to enter a plea. If found guilty, Johnson's facing a maximum sentence of 6 months in jail and a $1,000 fine. Representing the state is prosecutor Jill Gillette.
Do you want to talk to an attorney and discuss whether or not you have a defense?
No, Your Honor. I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
It sounds like Johnson could be trying to make a sovereign citizen type argument, challenging the court's jurisdiction.
All right, I will then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you
I
time.
object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations.
Well, your position is taken and I'm still going to do it.
Well, I object to you
Your
entering a plea.
objection is noted. Your objection is noted, and if the time comes, you can appeal that to the Court of Appeal.
I object to you entering a plea on my behalf. I do not grant you that right.
Sir, you need to stop. You're being in contempt of court.
It's
Missy,
false
I
imprisonment.
want you to stop talking, or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again, Title
Deputy
4,
Miles, could you
let's
come in and
see.
assist the defendant? Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
You can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers. The choice is yours. Either leave
Your Honor, I'm trying to
or
understand.
leave disruptively.
I'm not being
Why an
disruptive. I'm
attorney
just trying to
can go-
understand the nature and cause of the
All right,
charge.
officers,
But I'm still not understanding what you're charging me with.
goodbye. We are adjourned.
Judge Webster held Johnson in contempt of court. He served 1 day in jail. When released, the judge continued his $1,000 bond. Johnson is yet to enter a plea, and his case is pending. Next, we head to Atlanta, Georgia for an arraignment. Rodney Thomas has been charged with criminal trespass. A day earlier, Thomas, who has previous convictions for aggravated assault, battery, and drug possession, was arrested for urinating in public at a MARTA train station. Today, he appears before Judge Jesse Lall to hear if he'll be offered bond. The state is represented by Ginta Bickerstaff, who's recommending a $3,000 signature bond through pretrial services. Jay Kim, the public defender, agrees with the bond, but prefers that it goes through a jail diversion program called PAD, where community workers help people who've been arrested avoid incarceration. Bickerstaff strongly disagrees with that option.
Your Honor, the state's recommendation to have his bond through pretrial seems more reasonable considering that this defendant just pled guilty to a battery charge and he's currently on probation for that case as well.
Okay. Bond is set at $3,000. It's going to be a signature bond through the jail.
Judge Lall rules to allow Thomas to stick with the PAD program, and the hearing's essentially over. But it looks like Thomas wants to say something.
Mr. Thomas.
Yes, ma'am.
Why are you putting your hand up? And do you have something to tell me?
Yes, ma'am.
Please do not say anything. You got the best signature bond through the jail. Please, you have nothing to say.
Despite his attorney's advice, Thomas seems determined to make a statement.
I just wanted to state that I am not on probation. That case was closed.
Okay, you don't have to talk about anything else.
Mr. Thomas, you have 77 arrest cycles. Do you think I really care whether you're on probation or not?
No, ma'am.
Then why would you mention it?
Yes.
The only reason I'm granting a signature bond is because it's being recommended by the prosecutor. But I was looking at a $5,000 bond because apparently you do not know how to use a bathroom. Do you understand, sir?
Yes, ma'am. I'll do better, ma'am.
Very good. You are to stay 200 yards away from each and every MARTA station or property, including their sidewalks and their parking lots. Do you understand?
Yes, ma'am, I do.
And if you need to answer nature's call, do you know what that means?
Yes, ma'am.
You are to use a proper public restroom or the privacy of your own restroom. You are not to exhibit yourself in any kind of public way in order to relieve yourself. Otherwise, the state's it has its right to charge you with public indecency. Do you understand, sir?
Yes, ma'am, I do.
All right, I can't believe I'm telling a grown man how to use a bathroom. This is all shame on you.
Yes, ma'am.
Thank you.
Thomas was released on bond, but must continue his diversion program until his next court date. His case is pending.